Hello everyone, I am Mehendi Majumdar, a legal professional as well as an assistant professor of law at University of Engineering and Management, Kolkata. So till previous day, I have discussed the concept of right to life and personal liberty under Article 21 of the Indian Constitution. Now, we will discuss the scope of Article 21 with the help of justified case laws on this issue. The scope of Article 21 was a bit narrow till the 1950s as it was held by the Apex Court in the case of A.K. Gopalan versus State of Madras that the contents and subject matter of Article 21 and Article 19 Clause 1 and Clause D are not identical and they proceed on the total principles. So in this case, the word deprivation was construed in a narrower sense and it was held that deprivation does not restrict upon right to move freely, which came under Article 19, Clause 1, Clause D of our Indian Constitution. At that time, the Gopalan's case was the leading case in respect of Article 21, along with some other articles of the Constitution. But we can see in the post-Gopalan's case, the scenario in respect of Article 21 has been expanded and modified more gradually through various decisions of the Apex Court, and it was held that interference with the freedom of a person at home or a restriction which is imposed on a person while in jail would require the authority of law. So, whether the reasonableness of a penal law can be examined in reference to Article 19 was the point in issue after the Gopalan's case. But if we see the case of Maneka Gandhi versus Union of India, here the Apex Court opened up a new dimension and laid down the procedure cannot be arbitrary, unfair or unreasonable one. So Article 21 imposed a restriction upon a state where it prescribed a procedure for depriving a person of his life and personal liberty. This view has been further relied upon in the case of Francis Coralie versus the Administrator, Union Territory of Delhi and others. As stated earlier, the protection of Article 21 is wide enough and it was further widened in the case of Bandha Mukti Morcha versus Union of India and others in respect of the bonded laborers and weaker sections of the society. Now coming to the expanded scope of Article 21, we can see that this article has been explained by the Apex Court in the case of Unni Krishnan versus State of Andhra Pradesh, where it has been observed that Article 21 is the heart of the fundamental rights and it has extended the scope of Article 21 by observing that life includes education as well as right to education flows from right to life. Coming to the case of Kartar Singh versus State of Punjab, where the Supreme Court of India held that speedy trial is an essential part of fundamental rights guaranteed by Article 21 of the Indian Constitution. Then, in the landmark case of A.K. Bindal versus Union of India, it was held that no person shall be deprived of his life or personal liberty except according to the procedure which is established by law. Last but not the least, it is very much clear that Article 21 has a multi-dimensional interpretation. Any arbitrary, whimsical and fanciful act of the state which is depriving a person of his life or personal liberty would be against Article 21 of the